My name is Ben Hron again. I'm here to talk about navigating co-founder agreements, and more commonly known as founder agreements, same basic concept. The presentation, as I said, is going to run probably about 15 minutes, and then after that I'll stay online for the remainder of our available time to answer as many questions as I can. If I don't get your question, or if you have questions after the fact, please, by all means, reach out to me. My contact information is on this slide. It'll also be on the last slide at the end of the presentation. Also, I'll make the slideshow available to everybody who registered, so you don't need to furiously copy down the information or take screenshots or anything like that as we go along. So the obligatory legal disclaimer. This presentation is intended to be an overview of the topics covered. It's not intended as legal advice. The application of the information in the program to actual circumstances depends a lot on those circumstances, so please talk to your lawyer. Also, the information is current as of the date of this presentation, in this case September 23rd, so please please keep that in mind. All right. A little bit about me. So this presentation draws upon my experience representing both entrepreneurs and investors since 2003. During that time, I've sat on both sides of the table. I've helped entrepreneurs launch and grow businesses. I've also helped investors raise and deploy capital. For many of the companies that I represent, I act as an outside general counsel, advising on everything from general corporate governance to strategic transactions, financing, exit events. And this is a picture of me back when people actually did these things in person, and you had to dress up and all that. So for the various matters, many matters that I'm really not qualified to talk about, I'm fortunate to have nearly 400 colleagues with a diverse set of legal expertise and experiences. Collectively, we counsel companies of all sizes in nearly all areas of law that pertain to their businesses. So if you have any questions about me or McCarter, I'm happy to answer those offline. So a founder's agreement, for those who aren't familiar, is a contract among the founders and the company that is typically entered into around the time that the company is first organized, that covers key aspects of the relationship among the various parties to the agreement. A founder's agreement is a specific type of what's generically called a stockholders agreement, and includes many of the same terms found in a standard stockholders agreement, as well as some matters that are more specific to the founders. Broadly speaking, the provisions of a founders agreement fall into three categories. Those that deal with the control of the company and day-to-day activities, as well as major decisions. Those designed to align the incentives of the founders, so everybody's sort of rowing in the same direction. And those dealing with resolving disputes if they arise among the founders. Co-founding a company is sometimes compared to a marriage, so you can sort of think of a founders agreement as a form of prenuptial agreement for the founders. And as with a prenup, you probably won't need to review the document much if everything is going well. But if things get choppy, it's a really good thing, very helpful thing to have. I should mention that while I'm going to focus this discussion on corporations, because that is the most common form of entity that's used to start companies, the concepts in here apply just as well to entities or to businesses formed as limited liability companies or even as partnerships. The difference is that usually in those types of agreements, in those circumstances, the concepts that we're talking about here would be built into the limited liability company's operating agreement or the partnership agreement, as opposed to in a corporation where they typically are, these concepts usually exist in a separate contract among the company and the various founders. Before I dive into the specifics of what goes into a founders agreement, I do want to talk briefly about basically how you get to the founders, the split of the equity among the founders, because one of the key issues in a founders agreement is dealing with control, and control, and frankly also economics, comes out of the division of equity among the founders. And that becomes a pretty critical issue, because the way you structure your founder agreements, the provisions themselves, the way you decide that decisions will be made, is going to depend a lot on whether the co-founders are sort of co-equal, or whether they are disparate. So if you have one person with, say, 50+% of the company, and another couple of co-founders that are minority co-founders, you're going to have a very different type of situation than if you have, say, 3 founders all with 33% of the company. So it's important to keep in mind as you go through this that that split is ultimately going to determine how you want to set up some of the provisions in this agreement. So one of the ways in which founders agreement affects control of a company is by addressing the election and powers of the board of directors. In a corporation, the board appoints and removes officers and also oversees management's operation of the business. So management, your CEO, your president, secretary, treasurer, CFO, they are responsible for day-to-day affairs of the company, but the board oversees that and has the power to make major decisions for the company, or is required to approve them. And since board approval is required for things like raising capital, hiring and firing executives, sale of the company, issuing additional securities, control of the board becomes absolutely relevant to control of the overall company. Because the founders initially control most, if not all, of a corporation's voting power, they also collectively control who is elected to the board. And oftentimes the initial board is in fact comprised of just the founders. However, since not more than one founder can have a majority of the stock, and oftentimes no founder does, minority founders often want some reassurance that they will be able to continue to sit on the board as things go forward. So as I talked about a moment ago, if you have a single founder that has 50 or 60% or more of the company, they might have the ability to simply remove other founders from the board unless there's an agreement in place that ensures that all of those founders will have the right to sit on the board. So one of the common provisions in a founders agreement is one that says, in essence, all of the founders will vote in favor of each other to sit on the board of directors. The obligation to vote in favor of another founder typically terminates at some point. It doesn't usually go on forever, although it ostensibly could. And the key triggers there are things like a founder leaving the company, a founder's ownership percentage dropping below a certain threshold, or a financing of the company, because usually at the time of financing, the investors are coming in, they want a board seat, and usually at that point they want to make sure that at least some of the founders step down if they're not larger shareholders. Another way founders' agreements affect control of a company is by requiring approval of some or all of the founders to take certain corporate actions that otherwise would not require their approval. By statute, by law, there are certain things that stockholders usually have to vote on. Certain types of major transactions involving the company, certain types of changes to the charter, the charter documents. but those provisions usually require consent of the overall majority of the stockholders, not a subgroup of stockholders. So what the founders agreement can do is require that the founders specifically have to approve those actions, whether or not they constitute a majority of the shares overall, or whether or not the founders approving it constitute a majority. So for example, if the founders represented 60% of the company, you could have a provision requiring that a majority of the founders have to approve it, so 30+% of the company overall, even though that percentage of the company doesn't represent a majority of the overall shares in the company. The list of actions requiring founder approval usually includes any change to the company's charter or bylaws, issuing new equity, borrowing or lending money, acquiring another company or being acquired, and any transaction between the company and one of its founders or any related party. The agreement may also require founder approval of actions of particular interest to one or more of the founders. So, for example, if you have all your founders in one location, the founders may agree that they won't move the company, that the company won't be moved to another location without everybody approving it. You could have various other instances dealing with certain aspects of control of the business that might be relevant to the particular circumstance. It's important to understand that even though the founders are also oftentimes the board of directors, providing certain actions require approval of the founders is not entirely redundant of those actions also requiring approval of the board, because there are two key differences between actions taken by the board and actions taken by the stockholders. First, on the board, each founder gets one vote, right? One person, one vote. But stockholder votes are typically based on ownership interest. So you could have a situation where the founders, one founder has 50 or 45, 50% of the company, another founder has 25% of the company, another founder has 10% of the company. And on the board, those three votes would all count the same. But in the instance of a stockholder vote or a founder's vote, they would count differently. So in that scenario, the 25% holder and the 10% holder wouldn't be able to carry the day in a vote of the founders, but they would be able to carry the day in a vote of the three board members. So it's important to realize that those differences matter, and it may make sense for things to require founder approval, even if the founders comprise the entire board of directors. So it's important to think carefully when you're drafting your founders agreement about which actions should require just board approval or just founder approval or both. Since co-founding a business is a particularly personal endeavor, a founders agreement seeks to align the interests of the founders with each other and with the interests of the company. And this is accomplished by including what I generally call the three musketeer provisions. These provisions have two goals: ensuring that the economic interests of the founders and the company are inextricably intertwined, and preventing the actions of one founder from adversely affecting the actions of another. One way this is accomplished is by making it very difficult for founders to transfer their interest in the company to a third party. In fact, transfers are usually prohibited entirely, other than for estate planning purposes, unless the board of the company or the other founders approve of the transfer. By restricting transfers, the agreement ensures that the person making the decisions for the business is also the person who stands to gain or lose from those outcomes, so it aligns those interests. If a sale of the founder's shares to a third party is approved, a founder's agreement typically requires that the selling founder offer to sell the shares back to the company on the same terms as either the buyer or the seller. I'm sorry, offer to sell shares back to the company or sell the shares to the founders on the same terms. This ensures that all the founders have the same opportunity for liquidity, though in practice, oftentimes what it means is that you simply dissuade potential buyers. I'm going to pause for just a second. I see a bunch of questions on Slido, and I know I've been sort of pushing through this, so let me just pause for a second and see if I can answer some of these. There's a question here about, is the legal content of this presentation specific for Massachusetts only? No, it is not specific for Massachusetts only. It actually applies pretty generically, and in fact, most of the companies that we represent are Delaware entities, so that's not an issue. Another question. What's the role of general counsel? Is it for investor or for founders, or each party has their own counsel? The general counsel of the corporation represents the corporation. It doesn't specifically represent the investors or the founders. Technically, the general counsel reports to the board of directors. That gets a little tricky in circumstances where there's a split among the board as to what to do, but that is usually where the general counsel takes its orders from. There are instances where the general counsel will represent in some capacity the officers or directors of the company in a situation where they're negotiating with outside parties about matters related to the business. But if there's conflict between the board members or between the officers and the directors or the investors and the founders, then usually those parties go out and get their own counsel. There's a question about, does the general counsel only need to iron out the investment agreements, cap table, et cetera, during the finalizing the investment agreements? No, usually we get involved from the term sheet stage of negotiating financing documents, because frankly it is a lot easier to help the entrepreneurs along and also make sure that the terms of the agreement are mutually acceptable. A lot of times what happens is the founders, who oftentimes might be first-time entrepreneurs, don't know all the various issues that can arise from the terms that they're negotiating. So we help educate the founders on that and make sure that that stuff gets fleshed out at the term sheet stage, where it's a lot easier to negotiate than if those things basically don't get negotiated until the final documents. Question, what if one of the vetted co-founders is quit or fired? Equity has to be redistributed, right? I'm going to talk a little bit about repurchasing of shares in a second, so I'll get to that momentarily. Is it common to start off as an LLC with single ownership and later transfer to a C corporation? No, it's not. Typically, no matter whether it's one founder or many, if your intention is to raise venture capital, we usually see companies form as C corporations out of the box. There's a variety of reasons why that makes sense. Primarily, it's from both a tax perspective and from a cost perspective. LLCs make a ton of sense if you're going to do a service business, or if you don't intend to raise capital. If it's sort of going to be a business where most of the cash, you're not going to have a tremendous amount of long-term capital requirements. But if you're planning on raising money and then running losses for years and years and years, it usually makes a lot more sense to be a C corporation to start. Sorry, I'm just going to try to hit a few of these questions on the chat as well before we continue. Okay, I think that's, oh, I see a question. Oh, there we go. Okay, great. I think the questions on the chat have been answered, so I will continue on here. So now, right of repurchase. So another way that the founders agreement seeks to align the interests of the founders is by giving the company and or the founders the right to purchase shares from a founder if she loses control of those shares or if she's no longer involved in the company. So a repurchase in the case of an involuntary transfer, for example, somebody dies and their interest is transferred through their estate. If they get divorced and a portion of those shares are distributed to their spouse or former spouse, or if they go into bankruptcy and those shares are subject to claim by their creditors. In all those cases, the goal basically is to prevent a third party from acceding to the rights of the founder without the consent of the other founders. So going back to our Three Musketeer concept, we don't want somebody else coming in and basically becoming a pseudo co-founder, even though that person is involved in the day-to-day affairs. On the flip side, a repurchase following the end of the founder's service relationship with the company ensures that somebody who's no longer involved in the business is not making decisions for the for the business on a day-to-day basis. Looking back at the question, what if one of the co-founders quits or is fired? Oftentimes, sometimes the founders agreement will deal with that repurchase. Sometimes there's a separate agreement that deals with the repurchase of that equity. But in either case, I highly recommend that you make sure that the company or the other founders have the right to acquire the interest of any founder that departs. Now, usually that right to acquire shares decreases over time in what's called vesting. So initially, it may be that if somebody leaves on day 2, all of their shares can be repurchased. But if they spend a year or two with the company, only a portion of their shares can be repurchased because they've earned some of that equity over time. But I've seen situations in which the company has the right to repurchase all of the shares if a founder decides to leave the company. It just depends on the circumstances. There's a question: is vetting of estate transfers typically part of due diligence for investors or founders? So I think the question is getting at basically whether or not in connection with establishing a company or setting up in connection with the financing, will investors look at a founder's estate plan to see who is entitled to the shares? The short answer is yes, because what you'll be asked to do in connection with the financing is disclose who actually owns the shares and who has rights to the shares. So if you have transferred those shares to a trust, for example, for estate planning purposes, those shares would be, you'd have to disclose that. Now, they're not likely to look at your will, but they will look at agreements that determine whether or not the company has the right to repurchase the shares if those shares are no longer owned by the founder. Because one thing an investor doesn't want to do is have a situation where they invest in a company, and they're investing fundamentally in the people that are involved in the company, and then all of a sudden the people disappear and the company and basically they're now stuck having to deal with the person's relatives. So that's usually not a situation they want to be in. So with respect to the repurchase, while the circumstances in which a sale of the shares may be repurchased is obviously very important, it's also critical that the agreement address both the mechanisms for determining the repurchase price and also the timing of the payout, right? Because one thing the company doesn't want to get into, or the other founders for that matter, is a situation where they're repurchasing the shares, but they have to put up a large lump sum of money up front in order to get those shares. So usually the agreement both specifies how the valuation, how the purchase price is determined, and also gives the founders a period of time to pay that purchase price. Finally, on the subject of our Three Musketeer provisions, the founders agreement usually includes what's called a drag-along provision that requires all founders to go along with the sale of the business so long as the sale is approved by the founders as a whole, whatever the threshold is, whether it's a majority or a supermajority threshold. If the founders all agree that the company should be sold, all of the co-founders have to go along with that sale. And that's helpful in completing a sale, particularly if a sizable minority of the co-founders, more than 10%, oppose the transaction for some reason. There are usually some safeguards built into that to protect minority investors that require that all co-founders be treated equally, so that none of the founders get a special deal. And the last thing I want to talk about is dispute resolution. The founders agreement usually seeks to address the resolution of the dispute because when power is concentrated in the hands of just a few founders, a major dispute in the company can really bring the company to a standstill. You can imagine where there's either two founders that are 50-50 and they can't agree on something, or a handful of founders and they just can't get to a majority on something. The business can really be locked up, and it can prevent things from moving forward and really cause problems to the business. Founders agreements often provide that disputes will be resolved by arbitration or mediation rather than requiring people to go to court. Litigation is expensive, time-consuming, and pretty unpredictable. Arbitration and mediation, usually a much more controlled process. Arbitration, for those who aren't familiar, is a situation where two sides present their positions and the arbitrator makes a decision and it's binding on the company. Mediation is a little different. Everybody gets in a room. The mediator tries to basically help the parties to negotiate a mutually agreeable solution, but the mediator doesn't make the decision for the parties. Oftentimes, founders agreements also include what's called a buy-sell provision as sort of a last resort. And a buy-sell agreement is exactly what it sounds like. It is a provision that allows the founders to force either the purchase or sale of their interest in the company, so that you effectively get rid of one or more of the co-founders. Buy-sell agreements come in various forms, but two of the common ones are what's called, and I didn't make up these terms, one is called Russian roulette, and in that instance what you do is one party decides they want to trigger the buy-sell agreement. They send a notice to the other party saying, I believe the value of the business is X, and I'm willing to either buy or sell at that price, that valuation. So I will either buy your equity at that valuation or sell my equity at that valuation.
Hey, Ben, we're already over by 2 minutes, just time check.
That's fine. And a Mexican shootout is just a situation where each party submits a sealed bid, and whichever party bids higher buys the other party out at buys the other party out at the lower party's bid price. And then in the last resort, there's simply liquidation. If the parties simply can't agree on anything, they simply liquidate the company, which is usually a bad last resort, but in some cases it can happen. And that is the end of my discussion on founders agreements. A quick summary: founders agreements are like startup prenups. They help determine who makes major decisions for the company. They ensure that control of the company remains with the founders that are actively involved with the business. They prohibit transfer. The prohibitions on transfer and the drag-along provisions really tie the fate of the founders together. And the founders agreement helps provide a mechanism for resolving disputes. And with that, I realize this took a little longer than expected, but I'll I will be happy to answer questions offline if anybody wants to reach out to me.